The European Data Protection Board, EDPB, Guidelines 2020 on Articles 46(2)(I) and 46(3)(b) of the General Data Protection Regulation, GDPR, for transfers of personal data between European Economic Area, EEA, and non-EEA public authorities and bodies provide a comprehensive framework for ensuring the protection of personal data during international transfers. Adopted on 15 December 2020, these guidelines aim to clarify the application of the GDPR provisions on international data transfers, focusing on transfers from EEA public bodies to third country public bodies or international organizations not covered by an adequacy decision by the European Commission. The guidelines underscore the importance of providing appropriate safeguards for data transfers, in compliance with GDPR's Articles 46(2)(a) for legally binding and enforceable instruments and 46(3)(b) for administrative arrangements. They aim to ensure that data subjects' rights are enforceable and that they have access to effective legal remedies, regardless of whether the data is transferred under a legally binding instrument or through administrative arrangements subject to authorization by competent supervisory authorities. Key aspects of the guidelines. General principles for international transfers. Every data transfer must comply with GDPR's Chapter 5 and other relevant provisions, ensuring adherence to data protection principles, lawful processing, and special categories of data protection. Data protection principles and rights. The guidelines detail the necessity for the transfer instruments to respect core data protection principles such as purpose limitation, data minimization, accuracy, storage limitation, and security of data. They also emphasize the importance of ensuring data subjects' rights, including transparency, access to data, rectification, erasure, and rights related to automated decision-making. Safeguards for data transfers. The guidelines recommend including safeguards in the agreements between public bodies, such as restrictions on onward transfers, ensuring data security, and specifying data retention periods. Redress and supervision mechanisms. Effective mechanisms for data subjects to seek redress and for supervising compliance with the agreement are deemed essential. This includes the possibility of judicial remedies and the establishment of oversight mechanisms. Legally binding and enforceable instruments versus administrative arrangements. A distinction is made between transfers based on legally binding agreements, which do not require prior authorization, and those based on administrative arrangements, which do require authorization from competent supervisory authorities. Both types of instruments must provide for enforceable data subject rights and effective legal remedies. Procedure for administrative arrangements. The guidelines set a procedure for the authorization of administrative arrangements, including the need for a case-by-case examination by the competent supervisory authority and the application of the consistency mechanism. The EDPB emphasizes that these guidelines should be used as a reference by EEA public bodies when planning or amending international data transfer instruments, ensuring that personal data transferred outside the EEA is protected in a manner essentially equivalent to that within the EU.